Did you know there was a court case that stripped Native Americans of the exclusive right to their land that is still federally recognized? Writer Walter Echo Hawk describes the 1823 Supreme Court case Johnson v. McIntosh, which originated in the illegal purchasing and selling of native lands during colonial America. Once the United States became independent, the companies that participated in the illegal purchasing of land wanted their land titles federally recognized. To gain legal recognition of illegal land purchases, attorney Robert Goodloe Harper argued Native Americans had a right to sell their land, while the opposition, which was bribed by Harper, would argue that the purchase had been illegal under the Royal Proclamation of 1763. No Native Americans were consulted during the trial. The Supreme Court under Chief Justice John Marshall decided that the purchase of land under the proclamation had been illegal. However, the courts further added that since England discovered the lands of North America, they had gained a right to the land, and the U.S. had taken that right. This case resulted in the U.S. rejecting native ownership of land, reducing them to tenants upon what was now recognized by the U.S. as federal soil. The courts justified this, arguing that the tribes of Indians inhabiting this country were fierce savages, whose occupation was war, whose subsistence was drawn chiefly from the forest. Since this case is still legally valid, racist ideas of native savagery and U.S. overlordship over North America persist. The story of Johnson v. McIntosh is an example of Brayboy's second tenet of tribal critical race theory, which states that U.S. policies toward indigenous peoples are rooted in imperialism, white supremacy, and a desire for material gain. This is seen through how the federal government determined that because Native Americans were less than human, they could have native lands. The dehumanization of Native Americans as savages by the Marshall Court acts as a component of genocide. Gregory Stanton states that in a genocide, members of a persecuted group may be compared with animals, parasites, insects, or diseases. When a group of people is thought of as less than human, it is easier for the group in control to murder them. If a society is convinced that a population is less than human, then a society can justify further control and destruction of a people. Echo Hawk asserts that court cases founded upon racist laws should be restricted to prevent the further use of such flawed cases. Native people are not the dehumanizing stereotypes placed upon them. They are people like everyone else.